The land had always been quiet, the kind of quiet that came from long ownership and longer memory. It stretched wider than most people realized, a broad, gently sloping piece of earth bordered by aging trees and an old fence line that no one had repaired in decades. To outsiders, it looked forgotten. To surveyors who never bothered to check old records, it looked available. And to a powerful homeowners association hungry for expansion, it looked like an opportunity waiting to be taken. The owner of the land had inherited it years earlier, along with boxes of yellowed paperwork, stamped deeds, and county maps that dated back further than the surrounding neighborhood itself. The land had never been developed, not because it lacked value, but because it had been deliberately preserved. Taxes were paid quietly and on time every year. No signs were posted. No construction plans were filed. The land simply existed, legally intact and largely ignored. That silence became its weakness. The first sign that something was wrong did not come with warning letters or survey flags. It came with noise. Heavy machinery rolled in one morning without ceremony, chewing through brush and flattening grass that had grown untouched for years. Trucks followed, then trailers, then workers in reflective vests, who moved with the confidence of people who believed they had every right to be there. No permission had been given, no sale had been made, no lease had been signed, yet the work continued. At first, the assumption was error. Someone had misread a boundary line or confused one parcel with another. Mistakes like that happened, especially when large developments were rushed through planning commissions that trusted modern digital maps over dusty courthouse archives. A phone call would surely clear it up. A letter would resolve things quickly, but the letters sent to the HOA went unanswered. The calls were routed through layers of management companies and legal representatives, each one deflecting responsibility. The development, according to them, had already been approved. The zoning had already been cleared. The land, they insisted, was theirs to build on. The confidence in their responses made it clear that this was not confusion. It was assumption. The HOA had already decided the land was theirs. Survey stakes multiplied, roads were cut, utility lines were buried, concrete was poured, foundations appeared in neat rows, each one measured with precision and planned efficiency. What had once been open land transformed rapidly into the skeleton of a new neighborhood. 96 homes were outlined before any official response arrived. When a formal cease and desist was finally acknowledged, it was dismissed as baseless. The HOA attorneys cited recent filings, vague acquisitions, and development rights transferred through intermediaries. None of it matched the original deed. None of it aligned with county records older than the last 20 years. The owner noticed something important during this process. The HOA never once requested proof of ownership. They never asked for documentation. They never attempted to negotiate. They simply kept building. That decision changed everything. Rather than escalate immediately, the owner did something unexpected. The complaints stopped. The letters slowed. The landowner went quiet again, watching from a distance as the project accelerated. The HOA took the silence as surrender. Construction crews multiplied. Marketing banners went up. Model homes were staged. Flyers advertised a new exclusive community with amenities and long-term value. Buyers were lined up before the first homes were completed. Each structure rose on land that legally did not belong to the HOA. Every driveway poured, every roof installed, every lawn landscaped only deepened the problem they had created for themselves. The value on that land climbed with each passing week, and the owner knew exactly what was happening. The HOA believed money and momentum would protect them. They assumed that once families moved in, once mortgages were signed and lives were settled, no court would dare undo the development. They believed the cost of reversal would be too great, that pressure and public sympathy would bend the law in their favor. They were wrong. Behind the scenes, the owner began preparing, not loudly, not publicly, but thoroughly. Title searches were conducted going back generations. Certified copies of deeds were pulled from archives rarely accessed. Surveyors were hired to map boundaries based on original markers, not modern assumptions. Every document was cross-referenced, notarized, and preserved. What emerged was a paper trail so clean it left no room for argument. The land had never been sold. It had never been transferred. It had never been annexed. The HOA claims rested on a chain of ownership that simply stopped where the truth began. Still, the owner waited. The homes were completed. Families moved in. Mailboxes were installed. HOA fees were collected. The association celebrated its success with ribbon cuttings and promotional photos, proudly displaying a community that should never have existed. That was when the legal action began, not with threats, but with filings. A quiet lawsuit was submitted, challenging the HOA right to build and asserting full ownership of the land beneath all 96 homes. The case did not ask for compensation. It did not demand partial control. It asked for recognition of the deed, the original deed, the one the HOA had never bothered to check. The filing triggered panic behind closed doors. Emergency board meetings were held. Lawyers scrambled. Title insurance companies were contacted, only to discover exclusions that left them exposed. The HOA attempted to argue adverse possession, development rights, implied consent, and procedural oversight. None of it changed the fundamental problem. They had built an entire neighborhood on land they did not own. As the court date approached, the owner remained silent, letting the HOA exhaust its options. Publicly, the association reassured residents that everything was under control. Privately, the situation unraveled, because no matter how many houses stood on that land, no matter how many families lived there, the law did not bend for convenience. And when the deed was finally prepared for presentation, stamped and verified beyond dispute, it became clear that the quiet landowner had never lost control. They had simply waited for the moment when the truth would hurt the most. The stage was set, the court was ready, and the HOA was about to learn that building first and asking later had consequences far beyond fines or embarrassment. The next chapter would begin where their confidence ended, inside a courtroom where paper outweighed power, and silence became the loudest statement of all. By the time the lawsuit became public record, the neighborhood had already settled into routine. Lawns were trimmed weekly, trash bins lined the streets on schedule, cars filled driveways that had been poured only months earlier. From the outside, everything looked permanent, established, and unquestionable. That appearance was exactly what the HOA had counted on when they rushed the development forward without resolving the land's ownership. The filing changed the tone overnight. Real estate listings quietly disappeared. Lenders began reviewing files they had previously approved without hesitation. Title companies, suddenly aware of their exposure, started issuing internal alerts. The HOA board released carefully worded notices designed to calm residents while revealing as little as possible. The message was simple. The issue was a technical dispute, nothing more, and it would be resolved quickly. Behind the scenes, panic took hold. The HOA legal team began retracing their steps. attempting to reconstruct how a project of this size had moved forward without a verified deed. The answer was uncomfortable. The association had relied on a layered web of assumptions, digital records, zoning approvals, and a development partner's assurances. At no point had anyone physically pulled the original deed from the county archive. At no point had they confirmed that the land had ever been transferred out of private ownership. They had trusted momentum instead of law. As the court scheduled preliminary hearings, the HOA shifted strategy. Rather than address ownership directly, they focused on optics. They emphasized the families living in the homes, the children enrolled in nearby schools, and the financial damage that would occur if the development were challenged. They framed the issue as a threat to community stability rather than a question of legality. What they did not anticipate was the precision of the case against them. The landowner's filings were methodical, unemotional, and devastatingly clear. The legal argument did not accuse the HOA of malice or fraud, even though evidence suggested recklessness at best. Instead, it focused on facts that could not be argued away: dates, signatures, boundary markers, tax receipts spanning decades, survey maps that aligned perfectly with the original land grant. Every document told the same story. The land had never left private hands. The HOA attempted to introduce alternate records, but each one unraveled under scrutiny. Digital maps contradicted paper filings. Recent zoning approvals referenced parcel numbers that did not match historical designations. Development agreements pointed to ownership transfers that had never occurred. Each inconsistency weakened their position further. Meanwhile, the residents began to sense that something was wrong. Rumors circulated in online forums and neighborhood groups. Mortgage officers asked unexpected questions. Insurance companies delayed renewals. Homeowners who tried to refinance were told there were complications with title verification. Still, the HOA insisted everything was fine. The owner of the land watched all of this from a distance, unmoved by the growing tension. There was no rush. The longer the HOA delayed acknowledgement, the worse the outcome became for them. Each completed transaction, each collected fee, and each public assurance only deepened their liability. The court ordered a full title review. This was the moment the HOA had feared most. Independent examiners were assigned to trace ownership back to its origin, bypassing modern databases entirely. They went through handwritten ledgers, archived plats, and records that had not been digitized. They found the original markers, still referenced in century-old descriptions, and matched them to current boundaries. The result was undeniable. The land beneath all 96 homes belonged to one person. There was no partial overlap, no shared easement, no ambiguity. The development sat entirely within the boundaries of privately owned property that had never been sold, leased, or transferred. The HOA legal team scrambled to propose alternatives. They suggested forced sale at market value. They floated settlement discussions that involved retroactive purchase agreements. They argued that allowing the landowner to assert rights now would cause undue hardship. But hardship did not override ownership. The landowner declined all informal outreach. No counters were offered. No negotiations began. The case would proceed exactly as filed. As the trial date approached, pressure mounted from every direction. Residents demanded answers. Lenders demanded clarity. Developers threatened to sue the HOA for misrepresentation. The board members, once confident and dismissive, began resigning one by one. Public trust collapsed. In a last attempt to regain control, the HOA sought an emergency injunction to prevent the landowner from enforcing ownership rights until the case was resolved. They argued that allowing any action could destabilize the community and harm innocent homeowners. The judge denied the request. The ruling did not grant ownership to the landowner. That had yet to be decided, but it made one thing clear. The HOA had no legal authority to restrict the rightful owner from asserting their claim. That denial sent shockwaves through the neighborhood. Suddenly, the possibility that the land did not belong to the HOA became real, not theoretical, not distant, real enough to threaten everything that had been built on it. Real enough to expose how fragile the foundation of the community truly was. The owner remained silent throughout the chaos, confident in the strength of the evidence and the patience that had guided every step so far. The HOA had built an illusion of permanence, but the law recognized only what could be proven, and proof was exactly what the owner had in abundance. As the trial moved closer, one question loomed over every home, every contract, and every signature tied to the development. What happens when the ground beneath you was never yours to stand on? The answer would begin to take shape in the courtroom, where assumptions would be stripped away, and where a single document, kept safe for generations, would challenge an entire neighborhood's right to exist. The next chapter would follow the case as it entered that room, where confidence would collide with fact, and where the deed itself would finally emerge from silence. The courtroom did not look dramatic from the outside. It was plain, structured, and designed for order rather than spectacle. Yet everything about the case unfolding inside carried weight far beyond its walls. The dispute was no longer about paperwork or procedure. It was about consequences, about what happened when power ignored ownership and assumed silence meant weakness. As proceedings began, the HOA arrived burdened by optics they could no longer control. Their once confident posture had been replaced by visible restraint. Legal teams shuffled documents thicker than before, not because they had gained new ground, but because they were trying to obscure the absence of it. Every motion filed in recent weeks had been reactive, designed to delay or redirect rather than resolve. The landowner's filings, by contrast, remained unchanged. There was no escalation, no emotional appeal, no shift in tone. The claim stayed exactly as it had been from the start, recognition of ownership based on documented fact. The strategy was simple because it did not need to be complex. The law favored clarity, and clarity favored the truth. The court began with a review of the title examination ordered in the previous phase. Independent experts had completed their work without influence from either party, and their findings were comprehensive. They traced ownership through generations, cross-checking every transfer, every tax record, and every legal description. The process left no room for interpretation. The land had remained intact through time. When the results were entered into the record, the atmosphere shifted. The HOA argument that modern approvals and administrative actions had effectively transferred control began to collapse under scrutiny. Approvals did not replace ownership. Permits did not create title. Zoning authority did not supersede private property rights. The court acknowledged the scale of the development, but did not treat it as protection. If anything, the magnitude of the HOA actions only emphasized how far they had acted without verification. Building 96 homes was not an accident. It was a calculated risk taken under the assumption that no one would stop them. The landowner's patience was now being recontextualized. What the HOA had interpreted as inaction was revealed to be restraint. What they had mistaken for surrender was now understood as strategy. The court recognized that the owner had not waived rights through silence. There had been no consent, implied or otherwise. No agreement had been formed through delay. As the hearings continued, the HOA attempted to introduce the concept of reliance. They argued that buyers had relied on the association's representations, that lenders had relied on approvals, and that undoing the development would punish innocent parties. The court acknowledged the complexity of those consequences, but did not allow them to distort the central issue. Reliance did not erase ownership. Responsibility, the court noted, rested with the party that had made promises it had no authority to make. The homeowners had been misled, not by the landowner, but by the HOA that failed to confirm its rights before acting. Sympathy did not translate into legal immunity. With each session, the gap between appearance and reality widened. The HOA internal documents were subpoenaed and reviewed. Emails revealed haste. Meeting minutes showed warnings that had been ignored. Risk assessments referenced unresolved land questions that were dismissed as manageable. The development partner had urged verification early on, but the board had voted to proceed anyway, confident that any challenge could be settled later. Later had arrived. The landowner's history with the property was also entered into the record, not as sentiment but as context. The land had been preserved intentionally. Its boundaries had been respected for generations. Taxes had been paid without interruption. No encroachments had been tolerated, even minor ones, reinforcing the consistency of ownership. This was not neglect. It was stewardship. The court recognized that distinction. The owner's restraint had not been passive. It had been deliberate, grounded in the understanding that premature confrontation could complicate the outcome. Allowing construction to finish had not weakened the claim. It had strengthened it by eliminating arguments of partial development or unclear boundaries. By the midpoint of the trial, the outcome began to feel inevitable. The HOA final efforts focused on mitigation rather than defense. They asked the court to consider forced sale options, compensation structures, and delayed enforcement. They framed these requests as practical solutions, acknowledging ownership while seeking to soften its impact. But the landowner did not ask for compromise. The request remained singular, recognition of the deed. The court recessed briefly to review the totality of evidence. When proceedings resumed, the tone was measured and unmistakable. The findings confirmed what the documents had shown from the beginning. The land belonged to the owner. The HOA had acted without legal authority. The development existed on property it did not own. The ruling did not yet address remedies. That phase would come next, but the foundation of the HOA position was gone. Ownership had been established, formally and unequivocally. Outside the courtroom, the effects were immediate. Financial institutions froze transactions. Insurance providers reassessed coverage. Developers distanced themselves. The HOA remaining board members faced mounting pressure, both legal and personal. Inside the neighborhood, uncertainty replaced confidence. The streets looked the same, but their meaning had changed. The homes stood where they always had, but now every foundation represented a question rather than an asset. The landowner remained absent from the public narrative, allowing the ruling to speak on their behalf. There were no statements issued, no appearances made. The strategy that had defined the case from the start continued to hold. Silence, when backed by proof, was more powerful than protest. As the court scheduled the next phase to determine consequences, the reality settled in. Ownership had been decided. What remained was accountability, and that would be far more disruptive than anyone had anticipated. The next chapter would move beyond the courtroom and into the fallout, where legal certainty collided with human impact and where the cost of assuming ownership would finally be calculated. The ruling on ownership spread faster than any official notice ever could. Within days, the neighborhood existed in a strange state of suspension, where everything looked normal but nothing felt secure. Lawns were still watered, cars still came and went, but conversations stopped when neighbors approached one another. Every home now sat under an unspoken question mark, and no amount of routine could hide it. The court moved into the remedies phase with a tone that made clear there would be no shortcuts. The issue was no longer who owned the land. That had been settled. The question now was what would happen to everything built on it. The HOA arrived unprepared for this part. Their strategy had always relied on avoiding this moment. They had assumed the scale of the development would force compromise, that the presence of families and financial institutions would soften the law. Instead, the court treated the situation as a consequence of deliberate risk, not an unavoidable mistake. The landowner's position remained unchanged. There were no demands for immediate demolition, no public threats, no statements designed to inflame fear. The filings simply outlined the legal options available under property law when structures were built without consent. They did not ask the court to choose a specific outcome. They asked the court to recognize the owner's right to decide. That distinction mattered. The HOA attempted to regain control by presenting relocation studies, buyout proposals, and financial projections. They argued that allowing the landowner unrestricted authority would destabilize not just the community, but the local housing market. They emphasized how deeply the development had already been integrated into the surrounding area. The court listened but did not bend. Responsibility, the judge noted, followed authority. The HOA had exercised authority it did not have, and now faced consequences it could not shift onto others. The residents were not being punished by the law. They were caught in the fallout of a decision made without verification. That reality became impossible to ignore as financial pressure intensified. Mortgage lenders began issuing default warnings tied not to missed payments, but to title uncertainty. Insurance policies were revised or withdrawn entirely. Property values plummeted almost overnight, not because the homes had changed, but because their legal foundation had. The HOA reserves evaporated as legal fees mounted. Special assessments were proposed and rejected. Emergency meetings dissolved into blame and resignation. Former board members distanced themselves, citing reliance on consultants and developers who were now unreachable. Every layer of the organization began to fail. The landowner, meanwhile, prepared quietly. Environmental assessments were conducted. Structural evaluations were reviewed. Legal counsel outlined options ranging from leasing agreements to forced removal. None of these plans were announced. They were prepared as contingencies, not threats. That silence unsettled everyone. Residents speculated endlessly, filling the absence of information with fear. Some attempted to contact the landowner directly, hoping for reassurance. Others turned their anger toward the HOA, filing lawsuits of their own for misrepresentation and negligence. The community fractured along invisible lines. The court scheduled a final hearing to address enforcement. The focus would be on what rights the landowner could exercise and under what conditions. The HOA arrived that day with diminished presence, no longer confident enough to posture. They were no longer defending a development. They were defending their survival. The court acknowledged the human impact of the situation, but it did not allow emotion to override precedent. Structures built without consent did not acquire rights simply by existing. Occupancy did not create ownership. Investment did not override title. The ruling affirmed the landowner's authority. They could demand removal of the structures. They could negotiate usage. They could pursue damages. The choice belonged to them, and the law would support it. That authority landed like a shockwave. Outside the courthouse, the story shifted. Media coverage intensified, no longer framing the issue as a technical dispute, but as a cautionary tale of institutional overreach. The HOA name became synonymous with recklessness. Regulators began reviewing other developments under its control. The neighborhood waited. Days passed without announcement. Weeks followed. The absence of action was more unnerving than any immediate decision could have been. Every possibility remained open, and every outcome carried consequences. Then, quietly, notices were filed. Not eviction orders, not demolition demands, lease offers. The landowner proposed a structured agreement allowing the homes to remain in place under long-term land leases, priced at rates that reflected both market value and the risk imposed by the HOA actions. The terms were firm, non-negotiable, and legally sound. The HOA had no authority to accept them. The residents would have to decide individually. The impact was immediate. Some homeowners saw it as the only path forward. Others rejected it as unfair, refusing to pay for land they believed should have been theirs. Lawsuits multiplied. The HOA was named in every one of them. The landowner did not waver. The offer stood. Time limits were enforced. The law supported the position fully. As deadlines approached, the neighborhood split between those willing to adapt and those clinging to the illusion of reversal. The HOA, once the controlling force, had become irrelevant. And still, the most dramatic moment had yet to come, because the landowner had not yet revealed the final condition, one that would determine whether the development could truly survive in any form at all. That revelation would define the next chapter, where strategy turned into consequence, and where patience finally gave way to resolution. The final condition surfaced without announcement, without spectacle, and without negotiation. It appeared not as a threat, but as a filing, quietly entered into the public record, legally precise and devastating in its implications. By the time the neighborhood realized what it meant, there was no room left to argue. The landowner had attached a clause to every lease offer that most residents had overlooked in their desperation to secure stability. The clause referenced a conservation easement that predated the HOA by generations. It was tied directly to the original deed, recorded decades earlier and renewed periodically without fanfare. The land, while privately owned, carried restrictions on density, infrastructure strain, and environmental impact. Those restrictions had never been enforced because the land had never been developed. Until now, the easement did not prohibit buildings entirely, but it imposed strict limits that 96 homes exceeded by a wide margin. Septic systems, road widths, drainage runoff, and tree removal all violated terms that were legally binding and non-negotiable. The landowner had never waived those rights. They had never been nullified. They had simply been ignored by a development that assumed no one would ever check. The court reviewed the easement quickly. There was nothing ambiguous about it. What the HOA had built was not just unauthorized, it was incompatible with the land's legal use. That reality changed everything. Lease agreements could allow occupancy, but they could not override conservation law. Variances could be requested, but approval would require unanimous consent from agencies that had already expressed concern about how the development had proceeded. The illusion of permanence collapsed completely. Residents who had signed leases suddenly realized those agreements were temporary by nature. They bought time, not certainty. Residents who refused the leases found themselves with no legal standing at all. Mortgage holders accelerated demands. Insurance providers withdrew entirely. The HOA ceased operations within weeks. Bankruptcy filings followed, revealing a trail of mismanagement, ignored warnings, and internal communications that confirmed what the court had already concluded. The association had gambled with land it did not own, law it did not respect, and people it did not protect. The fallout was swift and unforgiving. Some homeowners relocated, absorbing losses that would follow them for years. Others stayed under temporary agreements, aware that future enforcement of the easement could still require partial removal of structures or infrastructure. A few attempted to organize legal resistance, but without the HOA as a shield, their efforts dissolved. The landowner remained consistent. There were no retaliatory actions, no public statements, no attempt to profit from the chaos beyond what the law already allowed. The goal had never been revenge. It had been recognition. Ownership had been ignored. Authority had been assumed. The response had been measured, patient, and absolute. Over time, parts of the development were dismantled. Roads were narrowed. Utility access was reduced. Several homes were removed entirely to bring the land closer to compliance. What remained no longer resembled the polished community once advertised. It became quieter, smaller, and far more cautious. The surrounding town took notice. Planning commissions revised approval processes. Title verification standards tightened. Developers became more careful. The story circulated not as rumor, but as precedent. A reminder that silence did not mean surrender, and that momentum did not replace law. The land itself changed too. Sections were restored, trees replanted, drainage corrected. The boundaries remained exactly where they had always been. What had been taken through assumption was reclaimed through patience. Years later, the case was still cited in legal discussions and real estate training sessions, not because of the scale alone, but because of the lesson it carried. 96 homes had been built on land no one bothered to confirm ownership of. An entire organization had operated on confidence instead of proof, and one landowner had let them finish, not out of fear, not out of uncertainty, but out of understanding that the truth, when fully revealed, carries more weight than any early objection ever could. In the end, there was no dramatic confrontation, no speech, no final declaration, just a deed pulled from the record, exactly as it had always been, and a neighborhood that learned, too late, that land remembers who it belongs to, no matter how much is built on top of it.
If you liked this story, please like, subscribe, and share it with others so they can learn something from it too.